David Whiting is here, your talkback lawyer, 1300 222 774. If you've got a legal query, we will try to help you, and I reckon David has heard it all. David, welcome.
Thank you, Raph.
Do you get surprised by people's questions?
Sometimes I get, I don't know the answer to that question. That to me, it's I love the, I've got to go and find out. Okay.
So maybe not surprised by people's human nature, but sometimes you get surprised by the little area of law you haven't quite come across yet?
Yes, yeah, or changes in the law. I mean, when I started, there was a politician by the name of Tom Reynolds who ended up being a minister, and Tom used to send me the explanatory memorandums that came with bills. So as you can imagine, as a young lawyer, I had a social life that you could kill for. And I used to read them to find out the what and the why without going and reading the legislation. And now that, of course, they're all online, but they're equally as boring as they were way back then.
You can read them to help you go to sleep. A little bit of homework before we get to
Yeah,
calls?
I had a correction and a homework. Last week we had a caller in relation to owners' corporations where there was a shared driveway. And I told the lady I spoke, so 2 units, shared driveway. And I told the lady that she needed owners' corporation insurance in respect of the common property. And a friend of mine who works almost exclusively in the owners' corporation area was monitoring the program and sent me an email before I got back to the office, says you're wrong.
Oh, great.
In the nicest possible way. And because there are a series of provisions in the owners' corporation legislation that don't apply to little two-lotters, right? One of them is the requirement to have insurance for common property. Now, I would have thought that it's really, really prudent to have insurance for common property. And, at a couple of $100 a year, it's peace of mind stuff. A million years ago, I once acted for a lady who bought a unit where the development, the 6 or 8 units in the development, was owned by a person who owned the lot and didn't insure anything. So it was a registered plan of subdivision. He owned them all, took out no insurance. After she bought, within the limitation period, somebody made a claim against the owners' corporation after falling on the stairs. Before my lady bought, but was within time, and the rules say that it was the owners' corporation that, because it was common property, that was responsible to the claimant. And I had a lady who couldn't afford to be involved in the proceeding. So there were no winners in that one. So for a couple of $100 a year, take the insurance. Now, from a homework point of view, I had a gentleman who had a query in relation to double parking.
I just like the fact that you're being live fact-checked. I just want to put that out there. It's a beautiful thing. Sorry.
Oh, no.
Double parking.
A driver must not stop on a road if to do so would put any part of the vehicle that the driver is driving between a vehicle that is parked on the road and the centre of the road. That's double parking. That's 3 penalty units. That's just under $500. So I'm terribly sorry. Double parking is no wriggle room on that one. Public buses. There are a series of rules that apply to public buses. If you're a private bus, that is, and a public bus is defined, so you're a regular passenger service, a school bus service, or a bus service operating along a fixed route on a regular basis, then you're a public bus. And if you're none of those, you just happen to be a large vehicle.
So you can't park in a bus zone?
No, it's just a large vehicle. And the High Court heard some argument this week in relation to prenups. And that will result in a decision being handed down sometime in the next few months.
I thought they were largely unnecessary in the context of Australian law. Is that
no?
fair?
They were actually introduced into legislation so that there was the possibility for you to fix your entitlements at the outset. And in this particular case, there was a lady who came from overseas as a sponsored migrant, presumably on a fiancé visa, and came to Australia and was asked to and did sign a prenup in the 10 days prior to the wedding. And the person she married was worth somewhere between $18 and $24 million. I have no idea what the terms of the prenup were. He has since died and she's come along and made a claim. So the question is, what's the effect of the prenup? So And
Does it override the will?
well, the answer would be I've decided that the whole of my it's not overriding the will. It's come along and said, well, you've been paid your entitlements under the prenup. That's it.
Okay.
You have no further rights. And so one of the questions that the court needs to decide is, was there duress in getting you to sign the prenup in the 10 days prior to the wedding? So you've gone through, you've told the world you're getting married, you've organised absolutely everything, and then it's my lawyers need to talk to your lawyers. And does that constitute duress?
It could, couldn't it?
It could easily. So the court's being asked to decide what's duress in these circumstances.
Okay, we will keep an eye on that one. It is 11 minutes past 10. Your calls are welcome on 1300 222 774. Annie is in Richmond. Go for it, Annie.
Yeah, hi David. Hi Ref. A body corporate question or a personal if I have to pay it myself.
Yes.
About a leaky pipe in a second floor unit and it leaked down to the 2 units below. We put coloured dye in the water to see if it was the drains or the taps, and that didn't happen. We then pulled the tiles off, and then there's the brickwork with the lumpy concrete, and the plumber cut the pipe. We found the leaky pipe, and the plumber cut the pipe out, and the pipe had been bent around the concrete to get to the tap when it was initially built in the 1950s or 60s.
Yes.
Do we have a body corporate, or do we have to pay it to fix the unit below?
It really depends on where the pipe is, Annie. Now, to do that, you're going to need to look at the strata plan or the plan of subdivision. Now, under new plans of subdivision, the boundary between a unit and the common property is the surface of the wall. So if you look at your unit, the walls belong to the owner's corporation and the paint belongs to you. Okay?
Okay. Yes.
Under the old law, was the law that existed when these came into being in about 1967, was that the boundary was the midpoint in the wall. So you can imagine under the new system, if it's a pipe that perishes in the wall, it's probably owner's corporation. If it's on your side, then it's your problem. So have a look at the strata plan. You would probably find that the owner's corporation will have insurance that will cover it.
Yeah,
now, but if I give you, well, go and make your own inquiries. You'll be able to see what the terms of the insurance policy are. And if they give you the name of the insurer and the policy, you can look on the insurer's website and download a copy of what's called a PDS, a product disclosure statement. But I once had a client, we had a flat in North Fitzroy, and what had happened was the waterproof ceiling under the shower, the membrane under the shower had perished. And so there was, every time he took a shower, there were drops of water on the ceiling downstairs. So that was his problem because it was the membrane, right?
Yes, yeah.
Okay, so you can do an online title search to get a copy of the plan, but you should also talk to the owner's corporation manager. They'll have one. And you're looking at what's the boundary between your unit. You want to find out whether the leakage is on common property or in your property.
Make sense, Annie?
No worries.
Thank you, Annie.
Good luck.
Thank you very much. Thank you. Bye-bye.
David's in Hampton. Go for it, David.
Hello, Raf and David. My question's about executorships in wills. My father died recently, and I left me as a co-executor in the will, and my other co-executor is his second wife, who's 94 years old.
Yes.
In my opinion, she's not capable of doing her duty, and obviously she thinks the same because she's delegated her responsibilities to her lawyer and her accountant.
David, has she proved the will? So has a grant of probate been made in both names?
Well, the will states there are two executors.
Well, no, that wasn't the question. What you consider the will to be a statement of choices. I'd like my wife and my son to be my executors.
Yes.
Now, somebody then makes an application to court to say I am, or we are, an executor named in the will, and we'd like you to give us a grant of probate.
Right. Well, we haven't got to that stage yet.
Well, the answer is that the lawyer and the accountant have no prospect of being appointed. So it's really a question of whether she could renounce probate, but it's unlikely to do so. You could get probate with leave for her to prove the will at some other future time. So it's really, I would be having a discussion with the lawyer and the accountant and simply saying, she's an executor, she has to do it properly.
Yeah, my problem is that there seems to be a vendetta. I know it sounds melodramatic here, but I'm being bombarded with legal threats from my father's second wife lawyer. So the only communication that seems to be possible now is through lawyers. My big irritation in this whole situation is that the other co-executor, my father's second wife, is not a beneficiary of the estate. And it appears that she's racking up enormous legal bills to absolutely no purpose.
Well, there are two sets of legal bills here, David. There's they're the legal bills that are. So, I'd be coming along and saying that to your stepmother that your solicitor is a totally unacceptable representative for the estate, and there ought to be a lawyer appointed by the estate to act for the estate, and there ought to be, if you want your own independent legal advice, which is what you're getting now, then the answer is that's fine. You should pay for it. And if I want to have the same, I'll pay for it. So, and who has the will?
It's currently, the original will is with the solicitor of the co-executor, who is also claiming to be the solicitor to the estate, notwithstanding the fact I haven't appointed her.
Then you should write her a letter and say that you intend to make an application for a grant of probate, with or without your co-executor, and that, but you're not authorising her to make an application, and she's not to deal with the will without your knowledge and consent, and you do not intend to appoint her as the executor of the estate, but you will negotiate with your stepmother for the appointment of a solicitor who can represent the interests of the estate, given that she is, based on the information she's given you to date, acting in the best interest of her client, not the estate.
Okay, David?
Okay, that's good. Thank you very much.
Thank you, David.
Good luck. Just a reminder, by the way, if some of the details slip by, you can listen back to any part of any show on ABC Radio Melbourne. So if you just go to the mornings page, you'll see there's a 3.5 hour piece of audio. It stays up there for a week. Just go about an hour and a half in, and you'll find David's section of that audio. So if you want to listen back to something that David has said, perhaps, and take some notes because of your situation might be similar, the audio is available there on the station's website. Mona is in East Bentley. Go for it, Mona.
David,
Mona.
I'm wondering, in July 2002, I made a will, and I asked my solicitor about doing a power of attorney for my two sons. I had the piece of paper, a copy no doubt, with my signature, her signature, and her receptionist or secretary's signature. I've recently been told that I need the signature of my two sons. Is that correct?
Is there room on the form for them?
Not really.
No, sorry. Is there a place on the form for them to sign?
No.
Okay, then the answer is no.
Right.
And that's because the legislation relating to powers of attorney have gone through a whole series of iterations. Mm-hmm. Right? Now, so... and every time they change the law in relation to powers of attorney, they introduce what are called grandfathering provisions, so that whatever was right at the time it was done remains right.
I see.
So if your power of attorney accorded with the law as it stood in 2002, then that's all it has to do.
I see.
So I've had a look at a power of attorney from the late 1990s recently, and it didn't even require a qualified witness. So there was no requirement for a lawyer to be a witness to an enduring power of attorney at the time this one was done.
Right.
So the answer would be no, it's not.
All right.
But sometimes you might need to get a letter of advice that says that the power of attorney complies with the legislation as it existed at the time, and in particular does not require the signature of the attorneys.
And do I get that from my lawyer?
Well, are you...
Or whom?
Well, I mean, it might be appropriate to update the power of attorney. But in which case the issue will be fixed because they will sign it.
Okay.
But if you want to rely on the 2002 document, then I think whoever you deal with will need to be persuaded that it's valid because it doesn't look like the one they saw yesterday.
Yes, I see what you mean.
Yep.
Now, and if I do a medical power of attorney, I would need their signatures.
The medical power of attorney form requires that there be that the person accept the role, and they do that by signing the document. The other thing about a medical treatment power of attorney is that you can't give it to two people. You can give it to a person at a time.
Right.
So I give it to Michael, but if Michael's interstate, overseas, or has died, then it goes to Harry, right?
Yes.
But I can't give it to Michael and Harry.
Right, I see.
So my way of dealing with that is say that I request but do not require Michael to talk to Harry before exercising his power. Right?
Okay,
So that way you bring everybody in the deal.
Right. Now, can I get their signatures to take along to the solicitor? Because I doubt whether they'd both have time to come with me.
No. They can sign. If we're talking about the medical one?
Yes.
For the medical one, all they need to do is sign. There's no witnessing.
Right.
So you would take the power of attorney from the lawyer,
right,
get your boys to sign it,
yes,
and then take it back to the lawyer to get certified copies.
I see.
If it's one of the new enduring powers of attorney, it requires their signature to be witnessed, but there's no qualifications for the witnesses. So it could be your next door neighbour, but preferably not you, and preferably not each other.
Okay.
All right?
I see. Fine. Thank you very
Mona.
much, David.
Good luck, Mona. And there's a supplementary on that from Margaret in Carnegie. Just a query. Did you want to know about where to get the power of attorney forms?
Yes, please. I tried on the Office of the Public Advocate, and
Yes.
I couldn't find it there.
In the Office of Public Advocate, the forms are there, but they're included in a booklet, which you can download and print the relevant pages.
And what's the booklet called?
It's on powers of attorney. It's a guide to powers of attorney.
Included in a booklet, Office of the Public Advocate.
Yes. Now, you can also download the forms from the Law Handbook, the lawhandbook.net.au.
Yep.
So the forms are downloadable. Yes.
Good luck, Margaret. Jeffrey is in Montmorency. Go for it, Jeffrey.
Good morning, team. Look, I've got a family friend, long time. She's separated from her husband for over 12 months now, and it doesn't look like he's going to get back together. I think he's got a few mental issues, though I'm not that close. He earns money cash in hand, most of it. She's got no name on either property that she's living in at the moment or the one he's in, the main house.
Yes.
She's in a bind. She doesn't know where to turn and what to do. I just need some advice on what her rights are. And she's got a 3-year-old and an 18-year-old son.
From the same relationship?
Yes.
Okay.
And they're married?
Yes.
So what's the issue?
Well, she doesn't know where she stands, being as she's got no name on anything. He owns a lot of Harleys and trucks and bikes and other odds and sods.
And well, I'm not going to ask you what kind of business is. We're not going to make this any easier for anybody else.
No.
Look, she's entitled to an equitable share of the property. What you advise people in those circumstances is get as much paperwork as you can.
And I think Jeffrey's concern is if a lot of the payment to the husband is cash in hand, does it make a difference to the share that she's entitled to after?
Yes, 90% of his income is cash in hand and has been
but it's
for
still declared,
over 20
presumably.
years.
Well, one lives in hope, right?
I'm not sure about that.
Look, what's going to happen is that if you look at the assets that they own, if they're inconsistent with the level of income he's declared, that's his problem. Mm-hmm. And what she might choose to do is say, well, this is what we normally spent. This is how much cash he'd give me. This is what we did. So I don't see, it will certainly make a difference, but I don't see it making a huge difference to the overall position. Consider the properties as being matrimonial. They're ours, as are the cars and the bikes and the trucks. All right?
And the other stuff should, I guess you'll just have to wait for it to sort itself out.
So it's really an inventory. What's there? And then the question would be, if I took out a mortgage, how did I pay it back? One of the interesting things that, I've sometimes looked at, Raf, is did I get a copy of the loan application to the bank? because the loan applications to banks normally have far more optimistic income figures than income tax returns.
Right.
All right.
Jeffrey, good luck.
Thank you.
Dave's in South Morang. Parking issue, is it, Dave?
Yeah, hi, good morning. My name is Dave. Yeah, look, I parked my car in the city, and I just parked the car, and I gone to get some money for the meter, and I got booked within like a few minutes.
Yes.
I wrote to the council and said, look, can you let this go? They said, no, I still have to pay the fine. So I'm not sure whether I should go to court or I should pay the fine.
When you say you went off to get change,
yep.
How far did you go?
Well, it's across the road.
Well, clearly if you were walking... Sorry, when they... how old is the meter?
How old is the meter? I don't know. It's in the city.
Well, sometimes my expectation would be that the parking officer will know how long the vehicle was standing before they issued the ticket. So they might know whether it's 2 minutes, 3 minutes, 5 minutes, 8 minutes, whatever it was. The expectation is that you'll go from your car to the meter.
Also, Dave, they've got
wait, no, it's not a meter where the car is parked. It's like a box. You got to go walk about.
Yes,
quite a distance.
Well, when I say quite a distance, I've never seen them with more than 5 or 6. So you might have to go up to 6 car lengths for the vehicle.
Yeah.
No, the answer is the expectation is you're in a position to pay, and they'll also tell you that they offer you the opportunity of credit card paying.
Yep.
And Dave, you might have a timing issue because there are sensors under the road in almost all of the Melbourne City Council parking bays. So they might be able to say, well, you parked your car at this time, and then 12 minutes later you put money into the meter. So they may have a very accurate recording of the time between parking and payment.
I'm sorry, David, but your expectation is that you'll be in a position to pay immediately you stop, which you can do by card or you can do by cash.
Okay.
Sorry.
All right, so I have to pay then.
I think you do, and next time... I used to have little coins in my car for parking meters until one day I got up and walked outside and found that somebody had broken my window for the car. Right. Yeah.
Might be worthwhile, Dave. I've got 3 different parking apps on my phone now because every local government area uses a different app. But once you've gone through the pain of setting them up, and it is painful, it can make a huge difference. It's made my life easier. Mind you, I am of moderate technical ability. It was a pretty painful process just setting up the apps. That's just the kind of guy I am. Robert's in Ringwood. What's your query, Robert?
G'day, guys. Just a question. I've been in a de facto relationship for 18 months, and basically I'm paying off my own house, and my girlfriend moved in 18 months ago now. The question is there any way that these binding financial agreements, are they worthwhile in court if, per se, if something goes wrong in the future to protect my home?
And you're de facto or married?
It doesn't matter. Okay. It doesn't matter. Look, Robert, the answer is we will know what the court tells us as to what constitutes duress. Now, in theory, you're contracting with a person you're going to share something with, whether it be a period of time or your life. And hopefully there's it's kind of hard. The expectation is that we'll be perfectly rational and not emotional in negotiating this kind of arrangement. But if you've got, for example, a young child and, if the relationships come to an end, you can leave and take the child with you unless you sign this binding financial agreement. Can you understand what kind of pressure or duress that might put a person under?
Oh,
so
absolutely.
I've had some clients who've thought that they would like a binding financial agreement. And I said, when's the wedding? My view is you have the binding financial agreement before you announce the engagement.
Yeah, that's fair enough.
You don't have it on the. We'll just go to the lawyers on the way to the church or registry office. So so the answer is the expectation is that they will work. The difficulty you have is inequality of bargaining power, and how you compensate for it, and what kind of external pressures might be on the parties to sign. I've made a commitment to, I've told my mother and father I'd be too embarrassed to tell her that, or to tell them that marriage isn't going ahead because I wouldn't sign a prenup.
Yeah, no, fair enough. I've got no intention of actually getting married at the moment, and nor there's no kids involved either. So,
right. Well, can I say that she will acquire property rights when you've been together 2 years?
Okay, that's why I'm actually concerned right now, because it's sort of getting towards 2 years, and I'm concerned that something's going to go down.
Then start that. Start the discussion now.
Have you spoken about it with your partner, Robert?
Oh, I have, and she's told me she'd actually sign that agreement, but I just want to know whether they're actually worthwhile when you actually go to a court.
My expectation is that they will work in circumstances where it's perfectly rational and no duress. The question will be, what do we do when there's duress?
Yeah, no, that's fair enough. No, I've been through a divorce before, and I just don't want to lose another house. I'm a bit scared about the whole thing.
Sure.
Good luck, Robert.
Okay, thank you.
See you later. David Whiting, thank you very much.
Thank you, Raph.
David is here every Tuesday taking your calls, giving you